For those of you that might not know me, my name is Greg Puig, and I'm the head of group insurance here at Sentinel Benefits, Sentinel Group. Super excited to have you all with us today. I'm going to be the moderator. We took a little bit of a different approach today, and it's not going to be like the standard PowerPoint slide deck. Really super excited to have Paul, Fallon, and Ryan join me and a panelist function, and I'll introduce them in a moment here. But a couple of housekeeping things before we dive in. This presentation will be recorded and will be posted on our web for future access. We will also send it to all attendees, so be on the lookout for that. I know we get that question a lot. You will have access to the recording, absolutely. We also highly encourage questions today. Please use the Q&A function at the bottom. That's the easiest one for us to monitor and organize. So it's the Q&A button at the bottom, and we'll be sure to tackle them. We've left plenty of time, knock on wood, hopefully plenty of time at the end here to be able to go through those. And if we don't get to your questions, somebody will absolutely be reaching out, and we could make sure that those get answered. Also, if you have takeaway questions from today, or you have questions relative to your own group, your own experiences, and you're just not quite comfortable asking them in the group setting, we're here. We're happy to help you. Following this call, we can set up a time to chat and talk, but really super excited about the content and the people that we have with us today. Just to set the stage a little bit, the world of benefits and retirement plans, it's really an ever-evolving landscape. It seems like we're constantly being inundated with legislative changes, both at the federal and at the state levels, and just the employee experience in general. They continues to evolve, and their needs and wants change, which feels like daily, but especially with the direction of the economy, with some of this legislation, with as we continue to navigate through this post-pandemic world, and especially with some of the recent news relative to the emergency ending and what the impact of that is on coverages and benefits. And it just seems like there's constantly things that we need to deal with, and that you need to deal with more so as a HR director, CFOs, and running an organization. So really today's focus is going to be on three major categories. So one, really, what is the impact of the state laws and legislation? And then the Secure Act 2.0 was a huge piece that was passed, and we've been getting a ton of questions on that on the retirement side. So excited to talk through that with our retirement plan expert. And then also things that HR professionals and CFOs can do to optimize their benefits packages in 2023 to kind of deal with some of those employee-centric, I wouldn't say challenges, but things to look for to be able to maintain the right offerings given the evolving marketplace that we just described. So couple introductions, and then that's enough for me for the moment. But joining us today, and a big thank you, is Paul Carelis from MP. So MP, for those of you who don't know who MP is a full service human capital company, and they offer a full suite of products and services that include HR, payroll, benefits, time and attendance, and compliance. And Paul's duties, he has over a decade of experience really overseeing their HR division. And he works with businesses of all sizes, SHRM certified, and along with his team, they're really focusing and helping clients on everything from compliance, training, HR guidance and support throughout the full employee life cycle, and much more too. So excited to speak with you again, Paul. We've done a couple of speaking engagements in the past, and excited to have you on the panel today and hear your perspective on things.
Likewise. Thank you so much. Looking forward to it.
Of course. So I'm introduced. I don't need to go too deep into my background, but like I said, I'm Greg. I've been with Sentinel for 12 years. I head our group insurance division here at Sentinel, and just really looking forward to hearing what the panelists have to say and taking a deeper dive and learning some stuff myself today as well. Next, we have Ryan Ransford. So Ryan's been with Sentinel since 2011. So we actually started right around the same time. And what Ryan's one of our plan advisors, retirement plan advisors, and he works directly with plan sponsors to help them with all types of their fiduciary risk, implementing fiduciary governance, and really focusing on the design, implementation, communication, and administration of the retirement plans. So Ryan, thanks for joining us, and looking forward to discussing Secure Act with you. And finally, but certainly not least, we have Fallon Carpenter joining us, also from Sentinel. Fallon's been with us since 2015. bring a really cool, fresh perspective from the HR standpoint. Really helps us to maintain our compliance, responsible for 260 some odd employees throughout the United States and across our 3 major offices. So Fallon, super pumped to have you here today. I think you give us a really cool perspective, and just looking forward to chatting through some benefit stuff with you. So enough from me. Let's jump into the fun stuff. Can you advance one more for me? So along those 3 topics. So Paul, I'm actually going to kickstart it with you. So you're going to be our first panelist to go today.
Sure.
Just because there's so much happening legislatively, and not, like I said earlier, not only on the federal level, but also on the state level. So what do you see in terms of those, laws, legislations really going through and being adopted at the state level? What are you monitoring? What are you talking to your clients about? And kind of what's on your radar from that perspective?
Yeah, no, there's a kind of trend of about 4 or 5 different topics that we're really seeing take hold in several states. The first of which has to do with pay transparency. So we're seeing that at the state level and also in certain cities. Typically, what that'll entail is that businesses who are posting for jobs within a certain state or city or location will be required to put the pay range for that job in the job posting itself. Some of the requirements in some of the cities and states also require posted pay ranges to employees in current roles, not just roles that they're hiring for, sometimes upon request, sometimes just generally speaking that they need to publish what the pay range is for a given position. And then in others, Illinois and California specifically, for businesses that have 100 or more employees, they're going to have to do a formal filing with the state that details out their compensation in accordance with certain demographic groups. So very similar to the EEO-1 filing that companies with more than 100 employees already have to do at the federal level, but this one dives more into compensation to make sure that there isn't discriminatory pay practices going on at an organization. Also, many states are adopting legislation through the Crown Act. So what that does is create a protected class surrounding hairstyles and hair textures when they have ties to ethnicities and ethnic heritages. So more and more states are adopting that as a protected class. We're also seeing, this is a newer one, but we're starting to see states look into the use of artificial intelligence and AI in hiring practices. So this is being looked at the federal level by the EEOC. But New York City has been especially aggressive. So they just enacted some legislation that greatly restricts employers from using AI when it comes to hiring decisions, that if they are going to use an AI software, it has to go through some bias testing and be certified as not being biased. And they also have to disclose their use of it to any applicants or candidates. And then from there, we're also seeing states in New England, Connecticut being the most recent, to further restrict the use of criminal records and criminal backgrounds in employment decisions. So in Connecticut, it's called the Clean Slate Law. That's going to reduce the amount of time and the types of convictions that'll show up on a background check and limit how those can factor into an employment decision. And then finally, something at the federal level that's really interesting. So states are continuing to enact legislation that restricts how non-compete agreements can be used. But what might trump that is the Federal Trade Commission recently proposed a pretty much universal ban on non-compete agreements. It remains to be seen if they have the ability to enact such a ban, but if they do, it would essentially eliminate all non-compete agreements, with the only exception being that if a business sells, then the owner who sold the business would be able to be in a legitimate non-compete agreement to not open up another similar business. But other than that, non-compete agreements would be a thing of the past. What we see on the state level is more restrictions. So saying that in order for a non-compete to be valid, it could only apply to an exempt employee or through a certain geographic defined mileage or something like that. But if the federal law goes through, then that would trump all of those.
Thanks, Paul. That was super interesting. From real quick on a state level, right? So you mentioned some federal and some state. What's your really what resource you usually recommend people looking at? Oh, geez, I wasn't sure on some of these. Or something you recommend other than partnering with the right,
Yeah.
benefits firm or HR firm? But like, is there anything that you any tips of the trade there? And it's okay if there isn't. I'm just kind of thinking out loud here.
Yeah, no, it's tricky. It's great if you have someone who's, human that's proactively advising you and knowing what states you're operating in, so they can alert you of the things that you need to be aware of. There are several, really good, excuse me, employment law firms out there that do daily, weekly, monthly newsletters. Those can often be a good source of information. But yeah, aside from that, it's tricky because yeah, there are so many different states that are quite active with their regulations, and then a lot of them will have different thresholds, like how you don't have to worry about it if you're under a certain employee count, or certain industry specific regulations nowadays. So as much as you can fine tune and have someone who really knows your business and knows how many employees you have, what state you're in, and what industry you're in, that's the best tool you can potentially have.
Perfect. Thanks. And Ryan, in a similar manner, the Secure Act 2.0 has gotten a ton of press and attention recently, and deservedly so. So along the lines of compliance and legislation, can you give us a little overview of what exactly the Secure Act 2.0 is, and then maybe some big things that employers should know as they're trying to navigate what it is, what the impact of this will be on their business?
Yeah, so it's funny. I feel like I've been talking about this for probably the last year and a half. This has been something we've known about for a while. It's been in Washington, and really three different proposed legislations, and they were all compiled in December, signed into law on December 29th of 2022. So really what we've been talking about for end of 2021 into 2022 is finally into law. And it was just a matter of what was going to go into it. So now we're kind of going through all of the Secure 2.0, but essentially what it is, it builds upon the Secure Act of 2019, which a lot of people forget because then shortly after the CARES Act came out during COVID. But Secure Act of 2019, now kind of dubbed Secure 1.0, was a large retirement legislation. Then it increased RMDs, for example, from 70.5 to 72. The big difference between Secure 2.0 and Secure Act is, first off, Secure 2.0 is much larger. So it's about 90 provisions, where I think Secure 1.0 was about 30. So it's much larger. And there's optional provisions. So Secure 1.0, for the most part, was all mandatory. Secure 2.0 includes a lot of optional provisions and a lot of different effective dates. So some go into effect as early as 2023, so as of now, and then some don't go into effect as late as 2028, and really, some of the changes don't fully go into place until 2033. So I think a lot of what we're talking about with clients and partners and just people with questions is kind of like, what do I need to know now, and what can we do now, and then what's going to come later that we may want to consider and prepare for. So there's certainly a lot there. I would say some of the big ones around RMDs, for example, got pushed out again from 72 to 73. Will then eventually get moved out to age 75 in 2033. But there's certainly a lot of mandatory provisions and a lot of optional provisions, all with different effective dates.
Thanks. And best way to similar to what I asked Paul, best way to navigate that, just sitting in the listener's shoes here, that's great intel. Like, what is it that their next best step would be? To partner with their advisor, or like Paul said, is it really an attorney type play and find the right compliance expert, or what are you recommending on that front?
Yeah, so there's a ton of great resources online. I mean, you can just Google, Secure 2.0, and you'll get tons of great articles. There is for a really in-depth review of each provision, which is probably too much for most folks, the Senate Finance Committee actually came out with a paragraph description of each. But what we've done internally is we've taken a lot of that information. Our risk attorneys have recently just put together a good summary that kind of lumps provisions into different categories and shows the effective date. So that actually, I'm excited to say, was finalized yesterday. and now we're going to be distributing it. So it'll be available on their website, which is great. There's we did a webinar about 2 or 3 weeks ago that's recorded that talks a lot about the mandatory provisions, the optionals, the different effective dates. So that's also on our website at sentinelgroup.com. But again, this is going to be interesting because a lot of the provisions on paper, they look great. And the question is, well, how is that going to translate to the operation side of things? And for a lot of our clients, they're like, well, how is this actually going to work? And a lot of the providers in the retirement plan industry space are also asking the same questions. So there's some provisions that we need a lot more clarity from the DOL and IRS. And, you know, like any legislation that they pass, they typically come out with additional guidance and bulletins. And so a lot of us are waiting on that. So we're going to have more information as the year goes on, as additional information comes out. The retirement plan industry tends to have a lot of conferences around April, as I'm sure most industries do. So we assume that we're going to get a lot more information in March and April, and we'll probably hold another webinar and have additional pieces available through our website.
That's excellent. Thank you. And a lot to unpack there. So I actually have a couple other kind of questions for you that I'll circle back in a couple of minutes. But before I do that, I definitely, Fallon, you know, like Ryan just gave us a nice overview of that, at least some background in this HERE Act. As you're looking forward to 2023, you know, what is it that you're thinking of from a new benefits perspective or new offering perspective or trends that you're seeing, you know, going into this year that you're really going to have on your radar as things continue to change and evolve?
Yeah, sure. So there are so many different offerings and so many different cool benefits that are out there. I think one of the big things for HR professionals to do is navigate those networks, make sure they are networking, going out to SHRM or NERA to really hear what is available, even perks conferences. And there's so much great stuff, but the first thing to do really is to figure out what does the population of your people actually want. If you're putting together benefits that a lot of your population don't care about, it's not going to do anything for you. So that's just one thing I think everyone should think about when they actually go to implement benefits. But a lot of the benefits we're seeing are in the space of mental health. A lot of companies are providing subscription plans to Calm apps. They're giving reimbursement for actual copays for therapy, some virtual online systems for therapy as well. You know, since COVID, so many employees have had burnout. They've had just stuff that has percolated through the pandemic that is really coming out now, and employees really need help. So we're seeing a lot of just mental health focus. We've seen people give mental health days off. Some companies are giving like a day for financial planning, wellness. It's like, take the day, go meet with a financial planner, get your affairs in order, because that's going to reduce your stress. So when you're at work, you can really focus. Same things, we're seeing people giving days off to go to the doctor. So really encouraging our employees to take care of themselves. So when they show up to work, they don't have to think about that. That's just one less thing they have to think about. And in the mental health space is flexibility. And so that's one of the easiest, cheapest things an employer can do is flexibility. If you entrust in your employees and work with them in terms of the schedule they need and know they're going to be oriented enough to get their job done, it's like flexibility is what employees are really looking for. And it's just something that it does not cost the employer anything. Other things that we've seen are actually bereavement is Sentinel's doing it. And I know a lot of other companies are, they're including loss of pregnancy into their bereavement program. So giving people space to really understand and process that grief that not only a woman might feel, but a husband, spouse, whatever that is. Fertility benefits are a huge thing. I know in the Massachusetts space, a lot of that's built into your medical plan already, but some states are not. And as companies start to recruit and have remote employees, that crosses state lines. And so that fertility benefit could be really helpful to your employees. Adoption benefits as well, whether that's adoption leave or adoption reimbursement to help facilitate someone starting a family. Those costs are pretty high. So having a program like that could be really helpful and inclusive to your employees. Elder care is another one as well. You know, a lot of our employees are straddling young families, but also really challenged with taking care of their families. So understanding what support they might need, and it might need additional help from a financial standpoint. So those are just some. And lastly, I will say is financial planning in general. If you can work with your broker to have your financial planners come out and do education, it is another thing that just relieves stress from your employees and helps them kind of be able to focus on some of the goals that those financial planners can set. And I could go on and on and on, but those are some highlights we're seeing for 2023.
No, that's super helpful. I'll throw one more on that list too, similar to how you just ended on the financial advisor side, meeting with your financial planner and providing that time. Another one that we're getting asked a ton about right now is just Medicare planning. As a lot of the boomer generation, maybe it potentially approaches retirement. I know last year was pretty tough market wise. So some people might be thinking about putting in maybe what their retirement data was off a little bit, but we're getting constantly asked right now about Medicare, about its impact on their own planning. A lot of people don't realize just how interconnected healthcare in retirement is to their financial well-being in retirement. Healthcare is often going to be one of their largest expenses in retirement. Everybody thinks of Medicare, which is a fantastic policy, but as an entitlement plan. And if you're not prepared for the costs associated with Medicare and what it takes to actually make the Medicare experience similar to what you've experienced potentially through your employer plans for as long as you've been employed, it could be a little bit of a culture shock. So we've been doing a lot of that. I know, Fallon, that's been something that has been a priority for you too. So just thought I'd add that one in there.
Yeah, no, that's a great one. I know we've done that in the past at Sentinel, and it's not only helpful for the actual person who's getting ready to retire, but also it could be someone like myself who my parents are starting to retire and they're really confused. So the more information you can get out to your employees to help navigate their personal lives is always super helpful.
Yeah, good point. So like one of those rare topics that could span no matter where you are in your career horizon, it could be relevant. So that's really well put. Thanks. There were some great ideas there. Really appreciate that. Paul, I want to jump back to you for a second. We
Sure.
covered a couple of compliance items already today, but what else are you seeing in employers like most commonly getting tripped up by when it comes to compliance?
Yeah,
And
great question. A couple of things. I think, we're definitely still in a point, or, the pandemic really ushered in a new era, and obviously industry specific, but so many more people opening up to hiring remote employees and hiring employees and that aren't close to their physical headquarters. Great, it's awesome. It really expands your potential talent pool, but it does come with some cautions, and one of them being that as you hire people, if they're working outside of the states that you've typically operated in, you now have to be aware and compliant with the laws in those states. When it comes to employees, you're responsible for employment law compliance in the location where they're working. So if your headquarters is, say, in Massachusetts, but you've got someone working from home and that home is in New York, you need to be aware and compliant with the laws in New York State. So definitely more and more people are coming around to that, but it still is catching some people off guard. Some people aren't kind of aware of that responsibility. So definitely an opportunity to update your handbooks, perhaps add some addendums for the state you're now in. Definitely familiarize yourself with the labor laws in those states. Some are more regulatory heavy than others. That's a big one. We're also seeing a lot of activity with the Department of Labor, especially in the hospitality industry. A lot of audits, a lot of reviews going on, mostly centered around a couple of things. First of which being child labor laws, making sure that, especially in industries where there tend to be teenage workers, that they're not working more hours than they're supposed to, or be working shifts outside of the hours that they're supposed to. Also seeing a lot of action regarding overtime. So making sure that employees are paid overtime when they're working the requisite number of hours in a pay week, and that also that overtime rate is being calculated correctly. And that's something that trips up a lot of employers too. So a lot of people just think if someone's an hourly employee and they make $10 an hour, that if they work overtime, then that rate is time and a half or $15 an hour. But Department of Labor observes what's called the regular rate. So oftentimes that can include certain commissions and bonuses and other compensation that's paid to an employee needs to be factored into their overtime rate when they do work overtime. So it's really important that if you do have non-exempt workers that are working overtime, that you're calculating that rate correctly. And then other than that, the National Labor Relations Board is really getting out there now. So you're hearing about it in the headlines when it comes to unionization efforts at Starbucks and Amazon and things like that. And they're certainly getting involved there. Definitely keeping a close eye on really any business that's having potential unionization or union election activity. National Labor Relations Board hasn't historically been one that's had a lot of monetary fines or penalties associated with themselves, but they did just introduce over the last month or two some new fines that are available to them. So if they found that an employer terminated an employee in violation of their National Labor Relations Act, right? So usually something around unionization efforts, that company can now be held liable for recovery of any financial damages that happen to that employee, whether it be lost pay, and everything from credit card late fees, repossession costs of vehicles and homes, child care costs, health insurance, you name it. So they do now have a pretty deadly monetary penalty available to them at the National Labor Relations Board. And I'll say, if we're looking at history as an example, when they're taking a look at these things, it doesn't always just affect the businesses and companies that are more susceptible to unionization efforts. They also want to make sure that businesses aren't doing anything that would potentially chill an employee's rights under the National Labor Relations Act. So what that means is that making sure that your policies and your procedures and your handbook are all written in a way that is in observance of the National Labor Relations Act and not doing anything to chill employee rights. So again, a great time to be reviewing your handbook and policies to make sure that they're current with kind of the latest winds of the National Labor Relations Board.
Yeah, those are great ones. Super helpful. I'll add two more in here too, just off the top of my head. I promised myself I wasn't going to do this, but sometimes I can't help it. One we've been hearing a ton about we've been educating our clients a ton about over the last year or two, and really this came out of the CAA, is the Mental Health Parity Act. So similar to what you said, and what triggered that in my head, Paul, was when you were talking with the DOL and how they're hungry to be searching for a couple of things. This is a big one. There's a really interesting article in Napa this week, and the DOL last year did an audit of 200 companies or 200 plans. Now, frankly, they were very, very large institutions, so it's not the best sample size, but all 200 failed to meet the mental health parity requirements set by the law. So,
wow.
The more complex your plan is, and candidly, for those listening, those of you that with self-funded plans, definitely something to have on your radar. Talk to your consultant and broker about, because you're the ones that tend to be most susceptible to potentially not adhering to the law, just because there's so much variability and opportunity for you to create your own plans. Those of you that are in the fully insured world, so direct to carriers, it's definitely still worth asking your broker, advisor, or consultant about, because a lot of the carriers are doing, well, depending on what state you're in, a lot of the carriers are adhering to the Mental Health Parity Act on your behalf, but it's always something, it's still it's up to you to make sure that's happening, to make sure that you think that your plan is adhering to the law. So that's just another one that I would just have on my radar. And then, Rye, what about on your end? I know you gave us a really robust response. I appreciate that in my first question I asked you, but are there any other, you mentioned RMDs, required minimum distributions. Are there any other mandatory provisions of the new Secure Act, the Secure Act 2.0, that you really want employers to know about, or anything else you want to go in any direction that you want to go relative to that?
Yeah, there's a few, and we won't cover them all today, but I guess some of the ones that we've been asked about recently and kind of get more of the attention are, I mentioned the RMDs. So that was one that, again, built off of Secure 1.0. So just to reiterate that, it's currently age 72, and it is going up to age 73, and then all the way up to age 75. It's going to phase out. So 75 won't be the RMD age until 2033. So 10 years from now, which is obviously a long time, but it's slowly, again, as the DOL and IRS look at people are working later and living longer, that RMD age is being pushed out. So they certainly don't want to, force folks to take money that they don't necessarily need. And that age has slowly, extended, which is great. Another one is the changes to catch-up contributions. So right now it's the, over age 50, or I should say in 2022 is over age 50. And, you can, in 2023, the catch-up contribution is $7,500. The mandatory change is it's kind of an additional catch-up, or I should say a change to catch-up for ages between 62 and 64, or I should say 60, 61, 62, and 63. So between 60 and 63, employees can do an additional catch-up of $10,000. It replaces the $7,500, so it's not on top of that. That's going to get indexed out. It doesn't go into effect until 2025. So we could see that, $10,000 amount be, 11, 12, 13 by the time it goes into effect. Probably not 13, but that's additional one as well. And then another one that is interesting is they're requiring a hard copy annual statement for all participants. So this was an interesting change because a lot of what has been happening over the last couple of years has been pushing everything to, e-delivery. A lot of people don't like it in the paper statements. Certainly companies don't like, doing the paper statements. They're requiring a hard copy annual statement unless the participant opts out. So that was an interesting one that took us a different route. So we'll have to see how that actually goes into play. That paper statement doesn't go into effect until 2026. So it's still a few years away. We could see some changes to that before it goes into effect, but certainly something to watch there. One of the ones that's getting the most traction, and this is for new retirement plans that are really created in 2023 or beyond. So some of you folks that say, well, our plan was created back in 1990. It's been around for 35 years. This doesn't apply to us, which is true. But for new plans in 2023, they're requiring automatic enrollment to go into effect starting in 2025. So for those folks that said, well, we've had retirement plans for years, so that doesn't apply to us. What it's going to do is all the new plans that have the automatic enrollment feature, because it's required, it really sets a new benchmark for all plans. So we're going to see the newer plans have higher enrollment because of that, most likely higher deferral rates, probably healthier compliance tests as well. So all the plans that have been around for a long time, which obviously is the majority, we'll have to take another look at auto enrollment to say, okay, is this something that we want to offer? Kind of the newer plans, newer competitors are offering this, and what does that look like from kind of a cultural standpoint and also from an operation standpoint. But we envision a lot of companies going back to the drawing board that maybe passed up auto enrollment in auto escalation and saying, okay, does this make sense for us? So that's one that's going to get a lot of traction.
Super helpful, Ryan. Thanks. And Fallon, keeping it going kind of like with the participants and involving them, how is it that you're going about engaging the participants outside of just open enrollment and really educating and engaging them year round on the benefits that are offered to them? What are you doing there?
Yeah, it's a great question, Ryan. I think probably a lot of people on this call can say that this is a struggle, right? You put together these benefits that are supposed to retain and recruit, and then so many times throughout the year, you find out that people had no idea they had a benefit that you offered, and you're like, wow, that hurts, right? Because we have that benefit for a reason, and no one knew it existed. So one of the things we encourage is to really think about a benefit strategy for the year. So you're going into the new year, it's January, you still have time to do this, but think about touch points and highlights of different benefits that you can really utilize throughout the year so that they're just not hearing about all the benefits during open enrollment. Because I think we all know this, during open enrollment, you are overwhelmed with all the benefits. And if there are changes, people mainly focus on the medical plan just to make sure they have that as coverage. And they're not really thinking about all the other benefits and or perks that your company offers. And therefore you're losing any type of gain you were trying to get for retention or recruitment. So some of the things that we do here is we think about different benefits we can highlight. So for mental health Awareness Month is May. So, you could utilize your EAPs, you could utilize your financial planners. So to kind of, again, showcase these offerings that you present to your employees at a different time throughout the year. You could do benefit statements. So it's just really thinking outside of the box about what your offerings are and how you can create a touch point for them and highlight them throughout the year. And I think a main piece of this is every employee is overwhelmed with email. We're burnt out. So you really have to figure out the purpose for the employee, because otherwise they're not going to engage with your email. They're just going to delete it. So again, thinking about the purpose, why it's important to the employee, and making sure that you're presenting it in a way. You could do videos, infographics. If you're doing email, make sure it's short and sweet. Webinars, lunch and learns. Again, just thinking outside the box to make sure that you're engaging your staff, because people are just burnt out, and you want to make sure that this benefit is helping them, not overwhelming them or just having them delete your email.
Awesome. Thank you. And Paul, back to you for a second, just because something I've been getting a lot of questions about in some of my recent client interactions, and something you and I chatted a little bit about already. But it's good. It'll be good for everybody to hear. What are some other things, and you mentioned a few of them already, but other things over at the Supreme Court that like employers should really know about or also keep on their horizon? I know it's as if we haven't given them enough to think about today from a legislatively compliance standpoint, but what else should they just have on their mind and just keep on a lookout for news-wise, or ask their advisor or expert about?
Yeah, there's a really interesting court case. The Supreme Court actually just agreed to hear it. There had been some similar ones that they had rejected. So it's interesting that they've agreed to hear this one. So this has to do with religious accommodation. So especially important to businesses who are open on weekends and holidays and things like that. So the case is called Groff versus DeJoy, and it has to actually do with a postal worker. So this postal worker is a practicing Christian. They had, requested to not work on Sundays. Historically, hadn't been a problem, obviously, as a mail carrier, where mail service hadn't been done on Sundays. But over time, the USPS started working with Amazon, and they agreed to deliver Amazon packages on Sundays. So the employee reiterated their religious accommodation to not have to work on Sundays. It was originally granted, but then things got busy, or they got short-staffed, or what have you, and eventually told the employee that they could no longer have Sundays off for religious practice. So the employee left. They sued. Historically speaking, these types of things have not been seen as a reasonable accommodation. They've been seen as an undue hardship on the business that they don't need to accommodate. So it'll be really interesting to see how this court case comes out and what the opinion actually says, as it could obviously have some real implications for all types of businesses when it comes to staffing and employees who wish to have time off for religious reasons. So we'll see how that shakes out. Also a case that we should be getting a decision on soon regarding overtime. So you want to keep an eye on Helix Energy Solutions versus Hewitt. That has to do with a highly compensated employee who was paid by the day rather than a guaranteed salary, but that daily rate equated to over $200,000 a year. But he's saying since it wasn't actually a salary, that he should have been entitled to overtime. So there could be some impact there on overtime. And then finally, speaking of overtime, the Department of Labor announced that they are going to be releasing their revised proposed rule for the overtime standards. It'll definitely impact what the minimum salary threshold is for employees to be exempt from overtime. There could potentially also be changes in job duty requirements and things like that. That'll be coming out in May. So keep your eyes peeled in May for the Department of Labor's release on the new overtime rules.
Greg, you're on mute.
I knew I was going to do that. All right.
I
Thanks,
saw you
Fallon.
saying my name, so I think
I was going right to you. Yeah. Well, what I was thinking is, so kind of similar to what I was asking Paul earlier, how could people stay on top? How do you stay on top of all these kind of evolving compliance pieces, on new benefits and perks the company could offer, on everything kind of HR? What is your kind of take on that? And what is it that you have put into your everyday practices relative to that?
Yeah, that's a great question. I think Paul hit on something that is relatively new for Sentinel. So right now we are in 26 states. So prior to that, we were in 2 states, right? So we knew Massachusetts law very well, and we knew New York law very well. And now we have 26 states. So it's really changed some of the vendors that we work with. We're actually working with Mineral to do our handbook. We just launched our newest handbook in January. The handbook is extremely long because we have 26 states that have their own laws and pages. And so we kind of have just a listing of all of our employees in all the different states, and then some of the major laws that we think might come up, different leave laws, different paid time off laws. As California, if you have folks in California, you know, it's very different. So we really try to stay focused on the highest level law, but we always have to go into our handbook or research when it comes up to an employee in a specific state that we really have no knowledge of. We have some employees are the only person in that state, and they have kind of wild laws that are happening. So, you know, it's that handbook has been really helpful. It updates us every time there is a new law, and I will say it's updated probably every other day. That's how frequent these state laws come out. So that's been super interesting for us. And then in terms of being compliant, we have a risk committee that we're always part of as part of an overall company. So one of the women who worked for me, she really handles compliance for us. We have a different poster system as well because they're updated more frequently than we have ever seen since COVID has happened. So there's just kind of a lot of more nuances to compliance than we really ever had to deal with before. And I feel like a lot of companies that might have gone the remote route are facing this. So it's just making sure that you have reputable partnerships, whether it's software you're using or MP, where you have like an HR consultant. It's nice to talk it out because sometimes when you read it, you're like, am I interpreting this correctly? I want to make sure we're acting on it correctly. So I would just say making sure that you have a lot of different sources for that information and making sure that you have checkpoints to make sure that you're actually implementing it correctly.
Yeah, really well put. I think another one too that I know you've invested heavily in, and I keep talking to my clients about too, is just having a really strong LMS solution, learning management system solution, right? Making sure, because there's just so much state by state requirements relative to what people need to be trained on nowadays. Having that right system that's going to adhere on the state by state benefits is critically important, wouldn't you say?
Yeah, absolutely. I mean, we currently use Mineral again for a lot of our compliance training that we have to do per state or overall employees, but it's just been kind of just a bigger piece of our day-to-day world than it ever has been before. So it's just really understanding, to Paul's point, what is the employee responsible for, and making sure that you have checklists and someone's heading it up and you're looking at it on a monthly basis, quarterly basis, whatever it might be. But it's definitely hugely important, and sometimes people kind of forget that that's a huge piece of what HR does.
Thank you. And Ryan, why don't we round it out here with you, and then we could check out the questions in the Q&A. So if anybody has questions, and we do have a few, please take the time to pop them in the Q&A now, and we're going to answer those in a moment. But why don't you finish off our official questions here? We went over the Secure Act 2.0 general overview. We went through the mandatory. Any optional ones that really stick out in your mind? And you have mentioned a few, but any other ones that there are a lot, as you mentioned, but are any ones that really you think that employers are really going to want to focus on?
Yeah, so I'll focus on the ones that are in effect for 2023, and then I'll share some in 2024. The ones that we're getting asked about, which are technically available to you right now, are employees can now self-certify hardships. So that was always a burden on the HR side of things, where, for plans that offered hardship loans, hardship distributions, from an audit standpoint, you always wanted to collect information so that, if your plan is subject to an audit, it was always it still is an easy flag to say, okay, well, it was one hardship, the auditor would ask for the supported documents, and that can really be a burdensome on the employer. But one thing they're allowed now is the employees can self-certify. Still some information to come out on how that exactly works. So more information there, but it is an option. And one thing I'll mention too, all these provisions that are part of Secure 2.0, you don't need to restate your document now with those provisions. So that won't happen until after 2025. So there's certainly some time where you could still adopt these, but just, document it, years down the road. Your record keeper may need some information from you if you want to offer these, but self-certify is definitely one of them. The other one that we're getting tons of questions about are employees. Well, employers can offer the ability for employees to accept company contributions as Roth contributions. So historically, employer contributions, whether it was a match, safe harbor, profit share, and non-elective contributions, have always been pre-tax, so that the company can take the tax deduction, the employees get the money, gross tax deferred. They can now take that as a Roth contribution. The employer has to allow for the option, and then the employee gets to select whether they want it or not. Now, there is some language in there that right now the employee can only accept it as Roth if they're fully vested. Because if you think about it, if they're not fully vested, they pay taxes on it, and then they may never get the money. So certainly some language there. But the big question is, well, how is that going to work? How does the employer go to each employee and say, well, what do you want, pre-tax or Roth? So we envision more guidance there, and there'll be solutions. But those are the top two. The one that's pretty interesting, and Fallon, this ties into some of the things you talked about, to get more involved in the financial wellness and financial well-being, employers can offer like gift cards for employees to now sign up for the 401k plan. So you could say, we're going to have a kind of a rally this week to get people involved in the retirement plan. So for anyone that signs up, we're going to give you, a $10 Starbucks gift card, which historically speaking, you were never allowed to do. It'd be counted as compensation, but it's excluded. So that's something that's pretty small. A lot of companies can adopt now, and it's really something pretty exciting. Some of the ones that in 2024 are in-plan emergency savings accounts. So again, Fallon, you mentioned some of the financial, well-being and financial planning things that you can offer to your employees. Plans can now attach an in-plan emergency savings account effective in 2024 that can hold up to $2,500. So it offers non-highly compensated employees the ability to save $2,500 to an emergency savings account that they can access tax-free, distribution, fee-free. So there's really no fees on it. It's a way where, through COVID, a lot of people struggled with emergency savings. And this is a way to try and combat that through the employer, which makes a lot of sense. The other one that's effective in 2024 that, has been around for years is having the employer match qualified student loan payments. So for employees that are making student loan payments, may not be able to save to their retirement plan because, they may be right out of college, paying for rent for the first time, paying back student loans. So they don't have dollars to direct towards the retirement plan. The employer can now say, okay, well, I'm going to match money that goes into the retirement plan based on what you're paying for your student loans. It's been around for a couple of years with a private letter ruling years ago, but now it's official where employers can adopt this effective next year, which is pretty exciting.
Excellent. Thank you. Rye, sticking with you for a second, because we did get a question in the Q&A. Is it true that the Secure Act 2.0 accidentally eliminated the catch-up contribution? Have you heard anything about that?
Yes. So there was that's a great question, and someone did their homework, because it actually came out a couple weeks after the law was signed. And it turns out the way the language was written for catch-up contributions, when they made the change, there was two changes. It was allowing the additional catch-up for those ages 60 to 63. One thing I didn't mention is it's going to require catch-up contributions for people that make over $145,000. You'll have to make it to Roth versus pre-tax now. But when they made that change, the way they writ the language, they actually accidentally, pretty much stripped out catch-up contributions. So this is very much an accident, and it's being addressed. So I would say we should, again, get some more guidance around that. It was brought up, a couple weeks after, just the way it read and the way it was written, accidentally did take out catch-up contributions, but it was an oversight. They admitted it, and they're going through to potentially make corrections and figure that out. But more information to come there. That actually was just released about a week ago, so it's still fairly new, and very much more information coming out by the day. But great question.
Thanks, Ryan. And Fallon, another really good one. Where do you find like the biggest gap of knowledge is with your employees and their benefits? And is it something that you does it vary? Are you focusing on anything specifically this year, or has it been consistent at all?
I think it varies, but a lot of times it's in the medical. So if there are like 3 different medical offerings and there's one that has a higher deductible or a lower deductible, a lot of people will generally stick to the lower deductible, even if that plan doesn't really benefit them that well. And so them utilizing like an FSA or HSA to kind of offset some of the cost is slightly overwhelming to them. So they just kind of pick the lowest offering, even though that's really not in the best interest of their medical history. So I think one of the things that we try to do is keep an open door policy. Like, if you're confused, like, please reach out to us. Let's sit down. Like, you don't have to get that in depth into your medical history if you don't want to, but we just want to make sure that our employees are picking a benefit that really benefits them and their families, and not just picking the lowest cost option because they don't fully understand how the plans work. And when you have a bunch of different offerings, that can be a challenge that we see.
Yep, totally agree there. Just from my purview, right? That's something constantly being asked about. No matter how much education we do, people get so confused by their medical offerings. That's why it's kind of like what you were saying earlier. Having a game plan to educate outside of just open enrollment can be really critical. Pick even small topics. It doesn't have to be long educational sessions. A topic on how to best view how your deductible works and how to best leverage the healthcare system is a really good one. Or the value of leveraging your HSA to help offset deductible-based expenses. There's a lot of ways you could do it. And, it doesn't have to be an hour. It could be 15, 30 minutes that people could get some really good takeaways with. So totally hear you there.
Or even create video content that you send out or something that they don't have to be present for.
Yeah, really good. We're using Brain Sharks more than we ever have. So small video type service. It's just a video based service technology that we can create, 3 to 5 minute videos on particular topics. So you're absolutely right, Fallon. That's really critical. Embed those in your Ben admin platforms or your payroll landing pages and intranet sites. It's really good option. So appreciate you mentioning that one. Paul, one for you. Your wealth of knowledge here. Where do you get your intel? What resources are you looking at to keep on top of legislative changes? Do you have any go-to websites or, foundations or anything like that you maybe sign up for?
Yeah, SHRM is a good resource. They've invested a lot over the last several years for their members in creating a lot of good content. Again, there's a lot of really good employment law firms, not to single any out. There are several good ones. I really like what Jackson Lewis puts out there, and Sheehan Finney for sometimes more of a local presence. McLean Middleton as well. Lots of really good employment law firms out there that put out really good content that's fairly easy to digest as well. And as Fallon said too, Mineral is a good resource as well.
Excellent. Thanks. Right. One clarifying question for you here. About catch-up contributions. Do they have to be a Roth contribution? Or you'd mentioned something about Roth contributions and catch-ups. Anything, does that jive your memory at all?
Yeah, so again, the two changes were obviously the increased amounts for that age of 60 to 63. The second change was and again, this was part of the Budget Act at the end of the year. So when they're included in the Secure 2.0, they really have to make sure the revenue is neutral or the changes are net neutral. One of those changes were as an employee who's making catch-up contributions, whether it's at 60 to 63 or just over age 50, you're required to do the catch-up contributions to Roth. This is effective 2024 for folks that make over $145,000. So again, it's more directed towards kind of the highly compensated individuals within the firm. But again, they would be required to make those catch-up contributions to Roth if they're over a certain income limit. And
Thanks
again,
for clarifying that.
2024.
Thanks. Appreciate that. Well, that ends today's session. We really appreciate everybody's participation. Great questions. And to Fallon, Paul, Ryan, really appreciate your time and your feedback today and answering all my questions. We hope everybody in attendance, you found today's session valuable. And again, this will be posted to our website. It will also be proactively sent to you because you did take the time to attend with us today, and we really appreciate that. We do have some upcoming webinars. They're not yet posted, but they will be. So always be on the lookout on sentinelgroup.com. And the same thing for MP. MP puts on some fantastic sessions. So just be on the lookout for some of their value-added webinars that they're constantly putting on. I hope this isn't the last time you see Paul. He has some great content that he likes to share on a regular basis. So to you three, thank you again. Really appreciate it. It was a great hour spent. And again, thank you to all of you for attending. And we will be posting these as soon as it's available. Have a great day, everybody.